All right, everybody, welcome to the show. This is the Creative Finance Collective. Every 2 o'clock p.m. Arizona time, we get together to discuss all things creative finance. So if you have questions, make sure to post them in the chat. We're going to be here as long as we receive questions, and we'll keep going as we get those questions. So if you have them, make sure to post it. A couple things to point out too. There's a barcode at the top of the screen. That is a barcode to the InRem Podcast YouTube channel. That is where the channel live feed lives, and really the best place to interact with us. So go there, subscribe. We'd really appreciate it. You can also find us on Facebook and X as well. So we're going to take any questions if you have those. Post it there. We've got on the show here with us Clair and Scott Horne. Hey, Scott, I see that you're on. Can you hear us? Yeah, Scott, if you're talking, we can't hear you and we can't see you. So I think you might want to log on and see what else is, or log on and make another attempt at that. All right, so we'll get started here. If you have questions, make sure to post them in the chat. And we'll get to those questions. We'll leave it quiet here while we wait for Scott and for questions coming up as well. Sean, I thought I'd ask this while we wait for some questions and see what you think. But last couple weeks, mortgage interest rates have really gone back up. They're almost 7.5% at this point. Have you seen any slowdown in creative financing? You're on mute, by the way.
Yeah, no, I mean, I haven't really seen any slowdown in. In fact, if anything, I see more and more people wanting to jump into, the creative financing sector as buyers, even consumers who are wanting to jump in and take advantage of some of the prior low interest rate loans of individuals who are looking to sell their properties or need to do something with their properties and move on. So I don't see any slowdown anytime soon until they figure out something to do with interest rates, or frankly, they should figure out a way to make the Fannie Mae and Freddie Mac loans assumable, and that might resolve some of this stuff. But
yeah,
obviously that's not a thing right now.
We got a comment from our friend Mark Monroe. He says not slowing down at all. Florida, I'm sure is busy out that way as well, and in a high interest rate environment, as you can imagine, seller financing, subject to financing, is really gives an investor a lot of options. Hey, Scott, I see you're on and your camera's working. Are you hearing us okay? We're not hearing you, buddy. We see you, but we can't hear you. We'll let him work.
Up there?
Oh, I hear it. Well, we hear you.
Man.
We hear you now. How you been?
Been good. How y'all?
Yeah, doing well. We're just talking about how expensive interest rates are and still are. And I imagine you haven't seen any slowdown in seller financing. What's it out like in Texas right now?
I will tell you where things have slowed down in marketing to buyers, not the acquisition side. So we still see tons of investors buying properties creatively and for cash, both, and what we're closing out there. But the resale side to homeowners seems to be slowing down a little bit. I don't know if it's because of the size of the down payments most people ask for, but for our own personal properties, we have seen a slowdown. Our houses used to blow off the shelves in 2-3 weeks. Then that kind of went up to 4, 5, 6 weeks. And we're seeing 60, 90 days right now on the properties. In fact, this morning I spent quite some time readjusting a lot of numbers finding the right mechanisms to help these things move. And I can't tell you yet if it's a down payment issue. Is it a monthly payment issue? Do people have concerns about payments? No, you still have these supply demand issues, right?
Right.
That are out there in your traditional retail marketplace. But from a standpoint of the seller financing, I can't tell you what it is. It's, I guess we were all so used to things moving so streamlined for so long. I look at this as it's just getting back to normal, really, that there's not really any issue. It's just getting back to normality. And you just have to get your mental process around it and adjust to it a little bit and go from there. But historically, guys, when you are in the investment industry and you're selling properties, you're always listening to the marketplace. What is it telling you? Are you priced too high? Are you priced right? Is your monthly payment okay? Is it too high? And you're always making a little adjustment, based upon what the marketplace tells you. And it seems to be, I don't know, you always start high because you can come down. You just can never go up. I get that. But, not too long ago, even the high-priced homes blew off the shelves. So I'm just seeing that the market cool a little bit in that retrospect, at least in the DFW marketplace.
Interesting.
Yeah, so maybe that's normality. I hope that's all it is. I will make another comment that I was talking to one of my other attorneys here yesterday about. Our foreclosures this month alone have tripled over last month. And of course, you scratch your head and you go, okay, is this signs of 08, 09 again? Is it just one of those things? Because we don't see a whole lot of foreclosures. And usually, most of those, the people do bring the loans current, even after the loan's been accelerated. And the lenders accept it. And I don't know what's going to happen this time around, but I just found it to be an interesting anomaly that, we handle the entire state of Texas for foreclosures for our investors. We don't do a lot. It used to be 1, 2 a month, 3 a month. A high month might be 4 or 5. And we got like 13 or 14 on the books right now. And you're scratching your head and you kind of go, what does that mean, if anything? And I think it's all okay. But it's just one of those things you see and you ponder, if that's the appropriate word to use. That's that big Texas word. We're going to ponder that situation.
Yeah.
We'll have to learn you Arizonians how to think that way. Okay.
Well, it's obvious to some extent we're in unprecedented times. Not that we would have high interest rates. That's not unprecedented. But to be in a system, because to your point about defaults or foreclosures, I've read multiple reports about credit card borrowers are seeing delinquency rates increase. All of this is a byproduct of a system that's designed to suck liquidity out of the system. That's what the Federal Reserve is trying to do to lower interest rates, or to lower inflation. They increase interest rates. They make things more costly to borrow, so on and so forth. But what's been so unique about the housing market is, you've never really seen, at least as far as I'm aware, a period of time that followed almost completely free money policy. So now we've shifted and gone the other way, but the whole world's sitting on 3% mortgages.
Yep.
So of course that props up the housing market. So how that plays out, who knows? But it's certainly if you're looking to home prices, it certainly benefited home prices, I think, by impacting supply.
Well, it drives those home prices through the roof.
Yeah.
Which becomes very problematic for, I think, your general population. For those people who have sold their their homes in California for these ungodly sums, or let's say in New York for that number, they move to Arizona or Texas. They skyrocket our prices. And now the common person is having a real hard time affording anything. And especially with the rates where they are, as Sean said earlier, you would think that it could affect some things. And on the retail side, we've seen the retail side, at least in DFW, slow down a little bit. It's just not as hot as a firecracker as it used to be. And Andy, I could probably comment about your liquidity in the marketplace, comment earlier, but I think I'd have to get on soapboxes about 100 feet high to do that. So I'm not going to go there, okay? I'm going to avoid that.
Okay.
You'll appreciate that.
Oh, well, we don't mind your soapboxes. Your life is just one big soapbox. Come on.
Or it's a soap opera, one or the other is what it seems like sometimes.
Hey,
I'll look over at my partner and go, there's the reason why.
Yeah. Hey, we've got a question. Good question. We'll get to that. By the way, if you're just now joining us, we're talking about creative financing. This is the Creative Finance Collective. We're going to take questions for as long as we get them. So if you're watching, you got a question, make sure to post it and we'll get to it. When should I use a wrap? Is there ever a time in subto to not use a wrap? So what are your thoughts on that? I know some folks transactionally like to use wraps all the time. Scott, I think you see it a little bit different. Sometimes it's appropriate, other times not. When and why?
I would love to hear, Sean's answer on this here in a moment. But from my perspective as the investor, and I'm that guy who's been around the block 16, 18 times, have tripped over the curb numerous times, those kind of things. But over my career, guys, though I've owned hundreds of rental properties at one time. I used to be Dallas County's largest Section 8 landlord twice in our career for single family homes. And I came to the point, at least in that side of our business career, that we didn't want to deal with that any longer. We had an economy of scale where we could have our in-house people handling the management, those kind of things. It just wasn't something I wanted to do. And as I got more and more entrenched into the seller finance world more heavily, I just started realizing it became, to me, if you look at an elongated timeline, rental property versus seller finance property, over the course of, let's say, 30 years, just to apply it to a 30-year mortgage, knowing that a rental property goes vacant every 18, 24 months, you've got all the issues of being a landlord, repairs, what it might be. If somebody moves out, you've got updates and repairs you got to do periodically along the way, yada, yada. I look at my seller finance world, and for every single rental property I can buy 1.5 owner finance properties. So I can buy 3 owner finance properties versus 2 rental properties. I can sell my owner finance homes at 110% typically, and I can get 110% plus monthly payment over rent. So when I look at that historically across this timeline, I think even though after 30 years, my house is paid off with the owner finance, and you own the rental property with some appreciation and some depreciation along the way, I think you get it to equal itself out. Now, all things equal in that regard, where do I go? I like the seller finance way because it takes less effort to handle that. People take better care of the homes. They make their payments more timely, typically, and things of that nature. So to answer the question direct, when you do, there's never a wrong time to do a seller finance. You have to decide who you are as an investor. What do you want to do? Do you want to be a landlord, or do you want to sell it and be a note holder? You have to make that decision. And there's not a right answer and there's not a wrong answer. It simply is what's best for the individual and for what their investment strategy is. And so I don't see a right or wrong anywhere. It's just, you've got to decide who you are, what you want to do, and where you want to be, and pull that trigger and go with it.
All right.
So as far as the structuring of the seller finance or the subject to, I always recommend using a wrap, or if you're outside of Texas, in Arizona, Wisconsin, some other states, you can use an agreement for sale, contract for deed, or land contract that allows the seller to retain title as security for the performance of the purchaser or buyer, and the performance being, I will either make payments to a servicing agent or I will make payments directly to the underlying lender. And the reason why I like that is, we had Eileen Brown on our In-Rim podcast a few weeks back, who, in my view, is one of the, premier escrow officers. Scott's office is right there as well, but she's one, in my view, one of the premier escrow officers here in Arizona, dealing with subject to transactions. And she said basically she's been doing wraps since, what was it, the 70s, Andy, 80s?
It's not a new thing.
It's not a new thing. And we've had a couple of cases, while I don't do litigation, we do have attorneys in our office that do real estate litigation, primarily represent real estate investors in litigation matters. And we've had a couple of times post-closing where attorneys have sent demand letters to our clients wanting to completely undo or rescind a subject to transaction, claiming that it's some exotic thing and, so unique and whatever. And in both of those, they were wraps. And we were basically able to go and say, look, this isn't a new thing. This isn't exotic. Wraps have been around forever. Oh, by the way, here's, where the IRS discusses wraps on their website. Here's, case law. Here's this, here's that. This isn't novel. This isn't new. If our client doesn't perform, your client has a remedy, and basically just shoved it down their throat and resolved the matter that way. Versus, I'm not sure we had the same ammo, honestly, if it wasn't a wrap. If it was just a seller conveying title to a buyer by warranty deed, and the buyer takes title subject to, or in the purchase contract says they would pay the seller's mortgage, but the seller really has no remedy if they don't pay the mortgage. That's really the issue, right? What are you going to just leave the seller holding the bag, or do you have you given the seller an ability to basically step in and take the transaction back over if you don't perform? Now, whether the seller has the means, the wherewithal, the ability to do it, that's a whole different story. Whether or not they will, maybe not. I mean, it really depends on the seller and whether or not they even want to be back involved. But nevertheless, it at least gives them that ability, that option. And so my recommendation is on subject to always either wrap it with a performance note and deed of trust or mortgage, depending what state you're in, or to acquire your interest via an agreement for sale, land contract, contract for deed, whatever they're calling it in the state that you're operating in. Obviously, Texas, you're limited to just the wrap style transaction for the most part. But
a quick comment, Sean, and what kind of in the same line where you're going a little bit. If I'm the investor buying a home, I prefer to buy it under a subject to transaction to limit my financial risks and issues. And if the seller wants additional equity through a second lien, great. Now, let's flip over a minute to if I'm selling a home, if I'm representing an investor, if I'm representing the investor buying a house and they want to buy it subject to, representing the seller, I'd much rather do a wrap loan, even though it might be a mirror wrap, as we call it, to the investor, than doing a subject to transaction. I just like the fact that there's a new note, new deed of trust, new terms out there. I think it gives you a little bit stronger position in the event of a default along the way. Obviously, to a back-end consumer who's going to live in the home, or even an investor that you might be selling to. If I'm an investor selling to an investor, again, I want to utilize a wraparound mortgage and not a subject to. Even if I'm going to stay in the middle of the transaction, I think you just get a little bit more control in that instance. And I think one of the important aspects of our business is to learn to be a control freak.
Yeah. All right. If you're just now joining us, this is the Creative Finance Collective. We're taking questions, so bring the questions. We have a few more here. Please share your thoughts using state contract plus subto addendum. So custom form or using the state promulgated contract form with an addendum. What are your thoughts?
So my answer is use the state form anytime you're allowed to use the state form. And what I mean by that is, Alan and I have had this discussion because he's a big fan of the TREC, and Scott's probably the same, where Texas has their real estate commission, which is a state agency that promulgates forms. In Arizona, we do not have that. Our Arizona Department of Real Estate does not promulgate forms. The only quote unquote state form that's available in Arizona is the Arizona Association of Realtors form. And oh, by the way, you must be a realtor to be able to use that form, because otherwise it's copyright protected. So they're the only ones with a license to use it. So if I go and find that form online, normally it's going to have a watermark on it that says that it's protected. But assuming that I found it online and wanted to recreate it, I couldn't. I mean, that's a copyright infringement. And so in Arizona, we don't have state forms. So if you're not working with a real estate agent or a realtor, not even a real estate agent, because you have to actually be a realtor to be able to use that form. If you're not working with a realtor in Arizona, you don't have a right to use that form. And so if you're going to purchase and sell without agents or realtors involved, you're going to have a custom form drafted by an attorney. That's just the nature of the transaction in Arizona. There's no other way around it. In Wisconsin, we have the WB11, which realtors and attorneys are licensed to use. So as an attorney, I can fill that out in Wisconsin, but we don't have a state, promulgated form that, anybody has a license to use, if you will. So it really depends on the state that you're in. But my preference and my recommendation is, if you do have a state form, use the state form and then create a custom addendum to that form that provides for all the subject to disclosures, the financing terms, all of that.
Well, Sean, I'm gonna echo that. Whenever available, I like the state promulgated form supplanted with proper disclosures along the way. A lot of people want to use other contracts that were generated out of other states, and they bring to Texas and they realize they're not sufficient. And of course, you should always be talking to that knowledgeable real estate attorney in your state to make sure whatever contract you're using at least covers your bases for the most part out there. So yeah, I echo that completely.
All right. I have another question. What are the key differences between buying a house sub-to with the seller's name on it, so buying it seller's name personally, versus a seller that has a house in the name of an LLC? Is the process still the same?
So no, yes and no. It can be the same or it can be different. And what I mean by that is, if you can have the LLC be the seller, you can buy the property from the LLC. Another option would be to, review the loan documents. But if this is, say, a commercial property and the seller is the borrower, and there's no other, protective language in the deed of trust or the mortgage or the note that would, prohibit this, you could just buy the ownership of the LLC if it's a single asset LLC, meaning single asset means the only thing that it owns is the real estate, and the only reason it exists is to own the real estate, then you could buy the membership interest in that and potentially not invoke the due on sale clause. So basically two ways. LLC is the seller, and you just do a standard transaction, or you do a membership interest purchase agreement in which you purchase 100% of the LLC's of the ownership of the LLC from whoever the individual or entity is that owns that LLC.
Well, by the way, Sean, I agree. If you're going to buy the LLC, just make sure you check tax issues, that your franchise taxes and or income taxes have been paid.
Right.
That's kind of common sense along the way. But whenever I see that, of course, my question is as you said very first, read the existing mortgage documents. Whose name are they really in?
Right.
The LLC buy it and they are reselling it. Does somebody else hold the first? Does the LLC actually, are they the borrower on that doc? Who is the borrower? Because you want to make certain that you have the ability to communicate with that existing mortgage company should you need to do so, vis-a-vis either a valid power of attorney or authorization form, something, just in case you need to do that. And I run into that situation all the time where, people want to resell houses and whatnot in various ways, but they don't think about how the back end, the new investor buyer, how can they communicate with the lender in the event they need to? And sometimes it becomes very problematic in getting those documents executed out there. So the key is before you go to contract with somebody, ask all these questions, anticipate what they're going to be, research the documents, as you said, Sean, and make sure they're all good in that instance, and make sure you have what the tools you need to navigate the transaction properly, and get off of your bed of roses, because things happen out there, and you need to have ability to do things sometimes and communicate properly. So I think the key is just being smart. And gentlemen, I don't want you to shoot me, but I've got a 5 o'clock meeting 15 minutes from here. That's a pretty big meeting. I meant to tell you guys that when we got on, I didn't do it. But so I could spend here for 30 minutes or so with y'all.
Yeah.
Right.
No,
Are we going to see you in Scottsdale next week?
Yeah, that's what I'm told. I'm just following
Right.
orders. I'll be on Tuesday and see you guys. I think I'll be down there on Thursday, Friday, Saturday. We're doing that grand opening for first option, title, everything else we're pushing out there.
Nice. Yeah, we'll be there on Thursday for sure.
So Andy, you bring the lobster. Sean, you bring the fillet. Okay.
Yeah.
surf and
good.
turf.
Yeah.
Anyway, sorry I can't say. I wish I could finish
All right.
it.
Sounds
All right.
good.
Guys,
Thanks,
posted.
Scott.
Thank y'all so much.
See you, Scott.
Bye-bye.
Bye. All right. So if you're just now joining us, we're taking questions. This is the Creative Finance Collective. So we're taking questions about all things related to creative finance. If you're watching us from Facebook, there is a barcode at the top of the screen that you can scan, and that will take you to our YouTube channel. Subscribe, like, we'd appreciate that. All right, Sean, we have one more question. We'll see if we get any other questions beyond this. The seller is selling a house subto in the name of an LLC. All right, hold on. I just in the name of an LLC. What's a way to get a limited power of attorney to talk on behalf of the LLC regarding insurance and other things to do with the property?
So, as Scott was saying, you need to identify who the actual borrower is on the loan. If the borrower is an individual, then get the power of attorney from the individual. If the borrower is an LLC, well, then powers of attorney do not exist for LLCs. LLCs cannot provide powers of attorney. They're not human beings, they're entities. And so, but that's not the end of that discussion. So, LLCs only act through individuals, right? So, like, I can't call up and say, I'm 1823 Mulberry LLC. Like, no, you're not. You're Sean St. Clair. You're a human being. Like, you can't just call somebody up and say, I'm the LLC. It's like, no, you're a representative or a member or a manager or somebody of the LLC. So because of that, what you do is you execute or you create a resolution of the LLC that complies with the laws of the state where the LLC is formed, which basically states and is signed by the appropriate members, managers, depending on the operating agreement, statutes, the whole thing. It's signed by the appropriate people, which basically appoint you as the authorized representative of the LLC to act on the LLC's behalf with respect to the property and the loan and this and that, and to receive information and to disclose information and to give instructions, and basically to be or act as the LLC or the representative of the LLC and do everything that the LLC can do on behalf of the LLC with respect to the lender. So it's a resolution that they provide to you that's properly, prepared and executed according to the terms of the state where the LLC was formed, as well as in compliance with the LLC's operating agreement, if an operating agreement exists.
All right. So we have another comment and a case study.
Okay.
It's kind of long. I'll read it. We'll see what thoughts we have. I'd like to give some insight on a lease option deal sold on. Tenant buyer defaulted. I could have done cash for keys, $10,000. The attorney I hired said, "Oh well, we'll get them out. Going to use the lease agreement only. So going to try to evict them." What happened? The tenant ended up with legal aid. Their attorney was great. Kicked my attorney's ass. Those legal aid attorneys are bringing the heat. All right. Let's see. They asked the judge to throw out the PSA because we're trying to remove the tenants from lease agreement only. The judge ruled to toss out the purchase and sale agreement. Then their attorney said landlord tenant laws, they need to be reimbursed for all the repairs. Oh boy. Came to find out they had 5 evictions in the state of Massachusetts. They don't record evictions to protect tenants. Oh, let's see. Ended up costing me $47,000. They played me well. Okay, yeah. So it turns out that it looks like they had a lot of prior evictions in the past and everything else.
Yeah, so that's from our good friend Mark Monroe there, posting this, and very experienced in subject to transactions, lease options. Even has a book out there on Amazon on creative or seller financing, and really good case study. So a few comments that I have. So first, I don't know why I do this. Maybe just kind of to see what's out there, Andy. So, I'm not leaving the firm, but nevertheless, I always look at the classified ads for, attorney job openings out there.
Oh, I thought you were going to say you're going to go over to legal aid.
No, but with that said, legal aid is always hiring. I'm like, why is legal aid having 10 job postings almost every time I turn around? They're posting. And I found out that there's been since COVID and all the, moratoriums and whatever, that the feds designated a bunch of funds for legal aid attorneys, and specifically legal aid attorneys to assist tenants.
Wow.
And so, when you used to show up to eviction court and the tenant kind of represent themselves, and your attorney that you hired and paid hourly, would just be able to kind of steamroll them, right or wrong. But because a pro per doesn't know what to say, what to do, or whatever. Well, that's no longer the case. Now they have these legal aid attorneys, and not only do they have legal aid attorneys now, but legal aid attorneys who work with a bunch of other legal aid attorneys so that their workload is less, right? Because it used to be legal aid had, so many cases that was like just churn and burn, right? Like, I just got to get rid of it. I don't have time to prepare. I don't have time to go, kick the other attorney's ass. Like, let's just get the case resolved, worked out, whatever. Well, that's not the case anymore. They have, a lot of funding now from the feds and tenants, are having their rights properly protected, which, in my view is a good thing, but I don't like tenants playing people, which sounds like it happened here. It sounds like maybe there was a certain level of injustice going on there. But nevertheless, what I will say is lease with options to purchase can work in certain circumstances. And it is a disposition method that you can utilize. But don't think that if you convey property or rights in property using a lease with option to purchase, that you no longer can be a landlord. Like Mark was saying here, you can't just all of a sudden be like, I'm hands off. Like, I gave you a lease with an option to purchase and now you're responsible for everything. No, you can only, at least in Arizona, there are certain things that typically landlords are responsible for, maintenance and repairs, that you can foist on the tenant, but you have to have this certain magic language in the lease and full disclosure and other monetary benefits that you can kind of, attach it to for the tenant to step up and do these things. But the one thing that you can't do, no matter what language you use, no matter what you say, no matter what your option agreement or purchase and sell agreement says, no matter what your lease says, nothing. You cannot contract around your duty as a landlord to provide a habitable dwelling. Okay, so that means, you can't have a roof that's leaking. You can't have, here in Arizona, a property without AC or heat. You can't have, electrical that doesn't work. You can't have plumbing that doesn't work. The dwelling has to be habitable. Mm-hmm. And those things will always be the landlord's responsibility, even if you've done a lease with an option to purchase where you view and they view it as their own piece of property. It doesn't work that way. Second thing, the lease should not ever reference the option to purchase or the purchase agreement. The lease should be its own standalone document. And then second, you should never provide, even in your option or purchase agreement, any type of credit on the monthly payments towards the purchase price. Because now all of a sudden, you're basically transmuting that lease and option into more than just a lease with an option or a lease with a purchase agreement. You're now basically saying that a portion of your rent is going towards your purchase of the property. Well, what do we call it when a seller retains title to the property, but a purchaser pays a set amount over time towards the purchase of the property? We call that an agreement for sale, a land contract, a contract for deed, right? So the court very well may look at that and say, yeah, you called it a lease with an option to purchase, but the way you structured it and set it up is the same as an agreement for sale or contract for deed. And oh, by the way, it doesn't have all of the same default provisions and stuff. So now you have to either file a quiet title action or you have to file a forfeiture or foreclosure action, similar to what you would do on an agreement for sale or contract for deed. So never apply a portion of the rent towards the purchase price. It should basically be two standalone documents, a lease that has the amount that they're going to pay monthly, and if they don't pay monthly, you convict them under the lease, and then an option to purchase with an option fee and a purchase price, or a way to accurately and 100% calculate the purchase price, or a purchase agreement with earnest money and a purchase price squared away. But now the option to purchase and the purchase agreement could have a lease and performance clause, which basically says, yeah, we're parties to this lease over here, and if you don't perform under the lease and you're evicted, then it terminates, this agreement. That's fine. Now, last point. You go into eviction court, you present the lease to the judge, which sounds like what happened here with this attorney. You present the lease to the judge and you say, okay, I need to evict. They haven't, made their monthly payments. Everything goes well until either A, legal aid shows up and starts waving around your option agreement or your PSA, or the tenant does that. Now, my position is legally, I don't believe, legally, the proper process would be to tell the legal aid attorney or the tenant, if you think you have a title right in this property, go take it up with Superior Court, but you do have a lease, you haven't made your mortgage your monthly payment. And so all I'm deciding here, who has the greater right to possess this property, and they should evict them. But that's not what they do. Instead, they say, oh, no, this is Superior Court, this is quiet title, I'm out. And, it gets one case off their docket, right? So it's like they're out, go see the Superior Court judge with your quiet title action, with your foreclosure or forfeiture action. They have an interest in the property because of these documents, and therefore I'm not going to evict them under the lease. That tends to be the way it goes. I don't think that that's the legal, right, correct, judicial or legal approach to it, but that seems to be how it happens. So with that said, leases with options of purchase are great and can be used, but just know that there's back-end risks that create some gray and could end up in situations like what Mark was dealing with. My preference for a disposition would be to do an agreement for sale, a land contract, a contract for deed, because in that case, the statutes are very clear as to the timeframes, the processes, the procedures. You're not dealing with the gray. It may take a little longer, but at least the gray is out. You know what you're dealing with. You know who's responsible for what. And frankly, you're not going to get stuck, at least in Arizona or here in Wisconsin. You're not going to get stuck with having to pay, money for repairs and things like that because they weren't a tenant. They were a purchaser. So that's something to think about for dispositions, is to, you utilize that method of disposition to cut out or eliminate the gray that comes with the lease with option.
Well, and speaking about the gray, another lesson to be learned from this is anytime you involve the courts, you're dealing with the gray. It's almost inevitable. You're dealing with somebody else who's going to make a decision. This jurisdiction happened to be Massachusetts, but as Mark mentioned, he had the option early on. Of course, it's easy to on Monday morning quarterback this thing, but he had the option for the cash for keys, right? Now he's wishing he did that. Boy, that sure sounds like an expensive option on the front end, $10,000 for cash for keys. But boy, by the end of this, it sounds really cheap, right? It's like, whenever you insert the uncertainty that is part and parcel of the judicial system, if you've got an option out to buy out, boy, you really need to be thinking about that. And I know you can only do what you're going to do if you're going to rely on lawyers that are like, well, screw that. We're going to evict these guys, and that's only going to cost you $800 or $1,500. It's like, well, okay, let's do it. But
us lawyers, and the more experience we have under our belt, the easier it is to make these recommendations. But a lot of times, you see these lawyer advertisements of the wolf and the bulldog and the this and the that and the guys out there that are all muscled and tatted out, and I'm going to fight for you and I'm going to get you your just results and all this, right? And it's like, oh yeah, I need a fighter on my side. I need an attorney that's going to go in there and duke it out and whatever. And I think a lot of times lawyers get burned, especially early on in their career, where they go with their gut, which is, pay the 10 grand and let's get out of this thing. Like, you don't even want to go into court. But then what happens is the client views them as weak, scared, unwilling to go fight and whatever, when in reality, it was just the smart recommendation. And, so a lot of times lawyers tend to then go to the completely opposite side where it's like, oh no, I'm going to go fight for you. Let's do it. Let's go win, because they want to show that, hey, I'm tough. I'm this, bulldog out there. I'm going to go fight for you. I'm going to go beat some people up in the courtroom and whatever. And then it doesn't always work out. So, it's always a catch-22. But my recommendation is, and I've had clients who have been frankly upset at me over it over the years, where I've suggested trying to get it resolved early on, and they're like, no, you just, don't believe in my case, and you don't this and this. Like, no, I know how this works out. And it doesn't end well generally. Even if you win, it doesn't end well. Like, you could get out for this amount now and just be done with it. And so to follow up on your point, which is an excellent one, sometimes, even though it pains you in the short run, it may be better to just pay the settlement, the resolution, and that is the known commodity, right? You know that that's what you have.
And it's a lesson. It's a lesson too to lawyers to start thinking about the price of settlement as part of the price, maybe, of the deal. If they're thinking about making your client get helping your client get the best deal, you need to be thinking about, the cheapest way out of this sometimes. In any event. Well, we've reached the end of our questions. So we'll go ahead. We're almost at an hour anyway, about 10 minutes out. Thanks everybody for joining us. Make sure to join us next week for the show and for the Creative Finance Collective. Come with your questions. The more questions we get, the more engaging it is. We appreciate that. And we'll plan on seeing you all next week.